Okay, I'm going to start. Barbara Kaufman, welcome to our first installment of our Return to Work series. We're hopeful that this series will inform you for the process that you employ as you make decisions regarding your return to work, and you ensure that when your employees do come back, that they come back to a safe workplace and that they have the comfort that you have done exactly what's needed or best informed policies at the time when you reconvene, because there's new information coming out all the time. Initially, we are presenting 4 installments. Today's focus is on legal considerations. Wednesday will be on environment and cleaning. And next Monday will be on social distancing and, if necessary, how to reconfigure your space. And then the last one in what we have planned so far will be on the science and the emotional aspects of the whole crisis and the sorts of things that you can do to help your employee base, again, based on best known information at the time. It's very possible that we're going to add a 5th or 6th or maybe even a 7th installment, depending upon the feedback that we get and also as new information comes out. So if you have an idea for a future webinar, either as part of this Return to Work series or on another topic that you think would be of interest to our members, please contact me. And let me know what you're thinking about and how we might be able to spotlight your company. I also want to say a little bit more about what else we have in store for this week. Some of you have been participating in our NRBP Nexus. That happens at 1 o'clock on Thursdays. Those are small group conversations led by me, Chip Halleck, and Maya Curry, and it's no more than 6 people per group, and many times it ends up being smaller. This is an opportunity to spend an hour conversing about leads and contacts and ways that we can all help each other. Then in the evening, we launched our Happy Hour series last Thursday and heard from John Ward, the General Manager of Cool Vines Newark. And this Thursday, we're going to hear from Dan Palsy, who's one of the owners and chef at Red's Beer Garden, and he will be talking about some German beers and pairing of German beers with food. Then the following week, we've tentatively agreed that DJ, the manager for the Sweetwater at the Haynes Building, will be speaking about a coffee drink that you can make at home. So we're trying to offer some interesting beginnings of each of those sessions and then opening it up to conversation to talk about whatever's on your mind, what connections we can help you to make. And we hope that this will be helpful to you as you weather this challenging time and be able to connect even though we can't be together in person. We are hopeful that we are going to be seeing the light at the end of the tunnel and being able to come together again, and we look forward to serving you now and also when we are able to reopen. With that, I'm going to turn it to today's presenter, Chris Dalton, who is a partner with Buchanan Ingersoll Rooney. And when Chris finishes his formal presentation, I'll be reading from the questions and fielding the questions to Chris. So if you have a question, please type it into the question box, and I will make sure that I pose those questions of Chris when we get to the appropriate point in the webinar. And then Chip Halleck will just greet us at the end because there may be some people that have joined midway, and he will go over the things we have coming up. And then hopefully we will see you again at one of the future sessions. So with that, I'm happy to turn it over to Chris.
Great. Thank you, Barbara, and I want to thank Barbara and Chip and Maya for thinking of me to try and come up with some thoughts and considerations as we navigate the COVID crisis here. As Barbara mentioned, I'm an attorney with Buchanan Ingersoll Rooney here in Newark. Well, actually today from my basement, not in Newark. We are about 425 attorneys spread over 15 offices across the country. We are a corporate law firm. We do a lot of business work, and in the context of this, our firm back in mid-March, created a COVID-19 task force with attorneys spread across all sorts of disciplines, and in an effort to try and provide our clients, our businesses, with guidance as we move through this process. You know, for nearly 2 months now, we have literally been coursing our way through uncharted waters with new regulations and government orders coming down every day. We've learned words like essential business, non-essential business, work from home, stay at home, social distancing, things that we probably never thought of 3 or 4 months ago. As we've all probably experienced, shutting down the economy 2 months ago was challenging, and reopening it is going to be as much of a challenge, if not more so. Barbara asked me to talk about legal issues and considerations, so let's start with 2 basic premises. The first one is that businesses owe their employees, their customers, their visitors, a safe and hazard-free working environment. And the second is that even when you do that, nothing can stop a lawyer from filing a lawsuit, but you can take steps to try and prevent or minimize those risks. And those steps would include having a plan to reopen, preparing the workplace to reopen, bringing employees back to the workplace in a manner that ensures their safety and their security, and also doing so in a way that complies with state and federal anti-discrimination laws, so that you don't run afoul of those as you're reopening. You also want to try and address individual concerns from employees with immunity issues or underlying concerns in the context of the ADA, the Americans with Disabilities Act. You also want to consider, when you're bringing back the employees, how you bring them back, and I'll touch on that in a moment. We've seen all sorts of new things come out of this crisis, and we're having to develop new policies and procedures to address things like pandemics. So that is something that employers should consider moving forward. And as I'm sure many employers here did 2 months ago, looking at your business plans, looking at your insurance policies, business interruption insurance, your contracts, your terms and conditions. There's a lot of things that have changed in this new environment. I was reading the paper this morning, actually one of our legal papers this morning, and there was a survey of business employers across the country, 150 businesses, and nearly 70% of them not ready to reopen. And so kudos to the NRBP for setting this up to help business members plan to reopen their businesses. In that survey, 64% of the employers said they were going to give their employers masks, gloves, other personal protective equipment. More than half of them said they're going to continue social distancing in the office. An incredible 83% of expressed a new openness to remote working and telecommuting. And of concern for some employers is there was a marked jump in complaints to the Occupational Safety and Health Administration, OSHA, from 3% of employers reporting complaints in March to 12% reporting in April. So that goes to the point of making sure that when you are opening your workplace, you follow the procedures that I'll touch on lightly, and that some of the other presenters later this week and next week will touch on in more depth. So, and just from my personal practice, we have seen a lot of COVID-19 lawsuits already. Probably some of you have seen them too. Lawsuits against cruise lines for canceled cruises, airlines to get your refunds, colleges and universities that were forced to go to distance learning are now being sued to get back some of the the fees, some of the tuition. It has just become a cottage industry. So everybody's a target. On the screen here, you've probably seen Governor Murphy's Road Back 6-point program. And if you can see it, you're going to notice that reopening is number 5 on that list. So it may be a while before we get there, but it's not too early to think about how to reopen, and it's not too early to think about doing so in ways that minimize your employees, your visitors, your customers' risks of contracting COVID-19, and thereby your business's exposure to potential liability. So what steps can you take to start doing that? First thing one should do, and Maya, if you can slide to the next slide, is to keep on top of the growing body of governmental orders and guidance, monitor state and local orders on what's permitted, what's limited, what's not limited. I give Governor Murphy's administration kudos on its COVID-19 website, faqbusiness.nj.gov. It's up to date. It's got very comprehensive guidance. So I commend that to your attention. Keep on top of the developments from the CDC, the Occupational Safety and Health Administration, Department of Labor, even the Equal Employment Opportunity Commission has provided guidance on how employers should do certain things in the context of this crisis. Our recommendation is that whatever guidance is applicable to your business, consider that a minimum. And if you can do more or you can do better, do it. Some businesses may have obtained relief under the CARES Act. And as you move forward, there are considerations that you should keep in mind regarding to the Paycheck Protection Program, tax advantages and tax credits. So you may certainly want to consider consulting with either a tax accountant or a tax attorney to make sure you're taking full and complete advantage of the programs that have been offered through the Paycheck Protection Program and the CARES Act. After taking a look at those considerations, you'll want to look at how do you prepare your workplace for reopening. And these are steps that you want to take, and that's the next slide, Maya, if you could do that. These are steps to take before bringing employees back to try and, again, minimize the risks associated with COVID-19 and the potential liability and litigation that could ensue from exposure to the virus. And additionally, from an employer perspective too, letting your employees know that you're taking these active steps to ensure a safe and hazard-free work environment ensures or can help to ensure and instill confidence in the employee that you have their best interests at heart, and thereby, again, try and minimize any complaints or concerns about the workplace. As Barbara stated, these are going to be covered in depth. On Wednesday, there's going to be a webinar on environmental aspects of the workplace and cleaning the workplace, and then next Monday about how the physical workplace may change post-coronavirus. So those are definitely things to keep in mind and take a look at. But in the interim, it's important for you as an employer or a business to map out how you're going to prepare the workplace to reopen and bring the workforce back to the workplace, whether you do it as an individual employer or as a team consisting of managers and perhaps other employees, to try and map that process out. And things that you would want to consider obviously are policies and procedures that comply with or exceed the advice that's being offered by state and local and federal agencies, how and whether to implement social distancing in the workplace, whether you want to have protective equipment for employees, visitors, others in the workplace, whether you want to take prophylactic steps to screen employees before they come to work. There's stuff on temperature screening and other means of screening employees and visitors to the workplace. Limiting the number of people in certain small areas, eliminating waiting rooms or reception areas or small spaces. these will be considered in depth on the other programs, but the important part is that by planning for and taking those steps, you can try to reduce the potential for exposure to COVID-19 in the workplace, and thereby reduce your business's risk of being sued for failing to take necessary and appropriate steps to protect the workplace. Once you've figured out how to protect the workplace, the next thing you want to do is bring your employees back to work. And most recommendations are to prioritize employees on the basis of their needs, their locations, their abilities to work remotely, seniority. If you have a collective bargaining agreement, you're going to need to work with the union on return to work processes. If you've received a loan under the Paycheck Protection Program, there are requirements there to maintain certain headcount levels and what to do if you fall below those levels for reasons beyond your control. It's fairly nuanced, and it's probably something that I would definitely refer to a tax accountant or a tax attorney that understands the ins and outs of the program. Continue to look at telework and remote working solutions. I think we've all probably found it fairly interesting how quickly we've been able to, for the most part, adapt to working remotely and telecommuting and those sorts of things in those areas in those businesses that we can do so. And as I mentioned, that survey that I saw this morning, 83% of employers responded that they are totally open to remote and telecommuting. Another factor to consider when returning the employees to work is in conjunction with social distancing or limiting the number of employees in the workplace, either staggered work hours or alternative day scheduling. There's a lot of interest in those sorts of programs, and again, I believe those will be covered in upcoming webinars. A lot of employers chose to furlough employees, which is different from laying off, and that the concept behind a furlough is that you're going to bring that employee back. It's a temporary loss of employment, and the intent is to bring that employee back. As you're bringing those employees back, you may find that some of them have found new jobs or moved on to different employers, so you're going to have to replace them, obviously. But at the same time, your business may have changed somewhat, and maybe you can't bring that employee back from furlough. You want to make sure that first of all, you didn't promise to bring that employee back. Take a look at whatever communications you put out when you issued the furlough. Hopefully it said, we would like to bring you back, we hope to bring you back, but you want to make sure that you didn't make a promise, because then you might have a contractual claim against you from the employee. You also might want to consider, if you can't bring them back, whether you would offer a severance package. The benefit to an employer, obviously, of a severance package is you oftentimes do get a release of claims so that the employment relationship is fully and completely terminated. Present circumstances being taken into consideration, we may not be able to do separation packages, but it is something worth considering. If you're going to keep the employees on furlough until you're able to bring them back, or hopefully able to bring them back, you do want to take a look with your benefits carriers if you are able to keep them on benefits. I know many employers have, while putting their employees on furlough, have continued to pay for or subsidize the employees' healthcare benefits, dental benefits, those sorts of things. So you're going to want to work with your providers to see if you can do that, and if so, how long. In addition to furloughs, obviously some people have laid off employees, and so you always have the option to bring back those employees who've been laid off. Nothing requires an employer to bring back a laid off employee. Obviously, one benefit of bringing back someone whom you laid off is that She knows the job, she knows the workplace, she knows the culture, so she can hit the ground running. There's no onboarding and learning curve. It can also help obviously improve morale around the workplace if people see their former colleagues coming back to the office. Whether to rehire or not rehire a laid off employee does have some risks. One of them is if the laid off employee is replaced with a new employee, you don't hire her back and she's replaced with a new employee, she may make a claim for wrongful termination that the layoff was a pretext for discrimination. If the company had a policy prior to this current circumstance against rehiring laid off employees and now turns around and reverses the policy, it could open the employer up to claims for disparate treatment or inconsistent treatment by a prior employee who was refused a rehire opportunity. So there are considerations to be taken into account there, to take a look at what you've done in the past and make sure that you continue to abide what you've done in the past, or change it. Sorry to be two-handed, change it as necessary to address current circumstances. When bringing people back from either furlough or layoff or whatever, you want to make sure that you do so in a manner that is consistent with state and federal anti-discrimination laws like Title VII, the New Jersey Law Against Discrimination, the Age Discrimination Employment Act, the Americans with Disabilities Act. They're the alphabet soup of employment protection laws. For example, consider if your plan is to bring back certain employees, and your prioritization says you need to bring back these two younger guys because they were working on a mission critical job that you need to get closed ASAP, and two similarly situated employees who are older are left on furlough. Clearly, this is a gross example of potential claim for age discrimination in employment. How do you protect yourself against that claim? As with any other, whether it's a reduction in force or a mass layoff, whatever, you want to make sure you look at the demographics. You want to make sure that you use objective performance criteria in determining who you're bringing back. If you've got performance reviews with a scale, that scale better match up with who you're bringing back. Don't rely solely on the subjective narrative, and critically document. What do I mean by that? Write down and justify everything that you're doing, so that if ever somebody is looking at these decisions in their rearview mirror, it's written down and recorded. Because as one of my colleagues always says, one of our top 10 rules of employment law is, if it wasn't written down, it didn't happen. So keep contemporaneous notes of what you're doing and why you're doing it. Another consideration for bringing folks back is, what if you have an employee who doesn't want to return to the workplace, or cannot or refuses to return to the workplace? Like we said, employees have a right to a safe and hazard-free workspace. That's under the Occupational Safety and Health Administration Act and other common law principles. You have to consider managing how you bring back or accommodate employees that have underlying conditions that may make them at greater risk to illness as a result of exposure to COVID-19. And you need to think about how you're going to respond to employees who just say, I can't, I'm scared, I don't want to come back to work. For example, if you have somebody who is immunocompromised, who you want to return to the workplace, but is fearful of exposure and contracting the disease, what do? My best advice would be, you start the interactive process under the Americans with Disabilities Act, as well as required under the New Jersey Law Against Discrimination. So that is, work with the employee to figure out how you can address the employee's concerns and try and bring them back to the workplace. You have to look at whether you can accommodate the employee's concerns. Is this a job that can be done through telecommuting until we all feel feel good that we've gotten past this this crisis. If not, you need to document the critical job functions so that you can demonstrate that we need to bring you back. You need to fulfill these critical job functions, and they have to be done here in the workplace. If not feasible, you could also consider, if it's a critical employee that you don't want to reach that breaking point with, whether that employee might be eligible for leave under the Family and Medical Leave Act to address those concerns. But at the end of the day, if it's a mission critical position, and if the job functions require that person to be in the workplace and you cannot accommodate it, you are permitted to terminate employees. So if it happens, you may need to consider termination. You may also have instances where employees don't have a good reason or justification for coming back to the workplace, and it's a terrible decision sometimes to have to make, but sometimes you may need to separate that employee from employment. You also, in connection with bringing the place back to work, I think I said earlier, you want to communicate with your workforce about what you're doing, how you're doing it, and what the steps are and stages are that you are going through to reopen the workplace. Part of that discussion should be expectations about returning to the workplace. Obviously, the ability to work with your HR or appropriate personnel about accommodating any disabilities, but be open about that and say, if your expectation is, as health and safety regulations permit, we want to get people back into the office, let people know that. You may have had an open enrollment period, something to think about. You may have had an open enrollment period or other policies and benefits processes. Make sure you don't miss those this year. May have to determine in the context of inability to either bring back the entire workforce or dealing with employees who will not come back to the workplace, if they should be separated from employment, and if so, again, as we talked about earlier, whether you have the ability or the capacity to provide a severance package that would foreclose any future employment claims. If it's a mass layoff, several hundred employees, depending upon the statute, whether it's the state Warren Act or the federal Warren Act, if you're going to have a large number of layoffs, that could implicate the notice and separation pay agreements of those statutes. So definitely, if it's looking like a large reduction in force, you'll want to consult with a labor and employment attorney who's experienced in navigating RIFs under both state and federal law. Once you've gotten through how to bring your employees back to work, you're going to want to take a look at what policies and procedures you had in place and what policies and procedures you might want to modify or institute. The mechanisms of instituting some of these policies that I'm going to discuss are going to be addressed in more depth on next Wednesday's webinar on the science of the virus, which Barbara mentioned. But as with all of these recommendations, the goal, again, is to try and reduce your potential exposure to liability from exposure to the COVID-19. Some employers are instituting policies of checking employees' temperature on their way into the workplace. We've seen this in the paper. Is this appropriate for your workplace? That's something to consider. But again, in doing so, you need to make sure that these protocols are medically checked and appropriate and comply particularly with the New Jersey Law Against Discrimination and the Americans with Disabilities Act, because you could run afoul of a claim of perceived disability. I've seen this in other cases. Right now, however, the Equal Employment Opportunity Commission has adopted guidance that permits temperature testing and shields the employer from potential liability under the Americans with Disabilities Act. That's something to keep on top of because as the crisis wanes down, the EEOC may modify that guidance. But for now, at least, there is a safe harbor provision for employers who want to institute these temperature check or other screening policies, again, to ensure the safety and health of folks inside the workplace. You want to keep on top, obviously, of this changing landscape of state, federal, and local ordinances. Make sure your policies comply with those ordinances and regulations. Make sure your sick time policy is crafted in such a way as to encourage people who are sick to stay home. Largely as Americans, we tend to soldier through and come to work with that cold or whatever. No, I think that's something we got to change and an attitude we got to change going forward. The Family First Coronavirus Response Act passed by Congress as Coronavirus Response Part 1.0, I believe, provided for paid sick leave, first time on a national level. We've had it in the state here for a number of years. See if your sick leave policies need to be adjusted to conform with the FFCRA, as well as make sure it's up to date with state policies on sick leave. One of the questions that comes up in this context is, what about employees who rely on public transportation to get to work? And I saw this morning that New Jersey Transit has had a 98% drop in ridership over the last month, largely, if not entirely, due to concerns about COVID-19. The Centers for Disease Control actually issued guidance suggesting that employers encourage alternative commuting as well as telework. What that means, it doesn't define, but it sounds to me perhaps if you were reimbursing, if you had a reimbursement program for public transportation options, you might want to temporarily consider Uber or Lyft as a public transportation option to get your employees to work. If you have employment agreements with employees, you might want to take a look at those, see if the for-cause termination provisions need to be adjusted in light of the strange things that have happened of late. A lot of employers are looking at their travel policies and eliminating non-essential travel, moving towards video conferencing options. We've probably all gone through every video conferencing option, including this one, over the last month, 6 weeks or so. One of the recommendations that bothers me is no longer having shared food platters, which means for the foreseeable future, there won't be any hobbies platters in my office, which is kind of sad. Make sure, again, continue to monitor all of these CDC, OSHA, DOL guidances. Make sure your policies are consistent with those policies and develop and implement training for your employees on these new policies going forward. Keep the workforce advised and informed of what the expectations are and what you as an employer will be doing to try and maintain and ensure a safe workplace. Last thing that's on my list of topics is to take a look at your business plans and your insurance policies and look for potential legal claims and things that you should do differently. Again, when this all started and as we've been going through this, I'm sure everybody has been looking at their business plan, looking at how they're going to make adjustments moving forward through the remainder of 2020. Take a look at if you haven't already done so, take a look at your insurance policies. Do you have business interruption insurance? If you don't, should you? And if you do, or if you do get it, look at what exclusions might be in there. I discovered to my detriment that my travel insurance policy actually exclusion number 19 was epidemics. So look and see if that's an exclusion to coverage. You may be able to negotiate a rider to overcome that, but I expect that that's going to be, the insurance industry will probably continue to write in epidemic as an exclusion. Moving forward, make sure you coordinate with your workers' compensation carrier to ensure that COVID-19 is covered, because if an employee does come down with COVID-19 and can demonstrate that it was directly linked to employment, you got a comp claim there. So it's a new one. Look at your contracts, both the contracts that you issue as well as contracts with your suppliers, your vendors, and others, and terms and conditions in those contracts. You know, we've all heard of force majeure claims or clauses. You know, what does your force majeure clause contain? Does it encompass a virus-related pandemic like we're going through right now? Is it a little squishy? That's a legal term. Can it be made clearer and more precise to ensure that, hey, the next time something like this happens, you're covered. You're covered for non-performance. You're covered for non-payment. Take a look through those contracts and those terms and conditions. Keep an eye on your creditors. Make sure they're not on the verge of insolvency. If they are, call your creditors counsel and make sure you're top of the list there for creditors. See if you can make sure that you're a secured creditor. We've all got our disaster recovery plans. Well, we need to modify our disaster recovery plans to look at things like this coronavirus pandemic or other outbreak. And you know, again, just keep on top of the ever-changing developments from state, local, and federal governments to make sure that you are complying with everything that you should comply with. And if you can do more or better, do so, because those are the things that will hopefully minimize your risk and ensure that you are providing a safe and hazard-free workplace for your employees and your guests. So that's my thinking on this. I appreciate the time here to try and kind of briefly highlight some thoughts on how we get back to the new normal.
Thank you, Chris. I think that was incredibly informative. You really covered a lot of bases with that presentation. I'm going to lead off with a question that came to my mind during your presentation. Let's say that you have either that you've never done an employee handbook or it's grossly out of date. Is now the time to do it proactively, or you know, what's the pro and con on that?
I think largely it's only pros, Barbara. I mean, you really want to make sure that any employee handbook or manual or policies that you have in place are up to date. You know, there have been changes in the New Jersey law against discrimination in the last year that you need to be aware of. I think it's a good practice to review at least on an annual basis to make sure that you know, you are up to date. And COVID virus notwithstanding, I would, you know, encourage employers to do that because it is a changing landscape always.
Mm-hmm. And for a company that doesn't have the budget to hire an attorney to help them through that, are there any sites that are guidelines for what an employee handbook should contain? And for online advice? Yeah,
I'm pretty certain that I'd have to look, but I'm pretty certain both the EEOC and the New Jersey Division on Civil Rights have guidance for employers. You don't necessarily have to hire an attorney to write an employee handbook for you if you have an HR person who's a member of the Society for Human Resources Management. They are a good resource to turn to. Some ADP even has gotten into the employee management sphere, so they could be a resource as well. But the critical thing is to just make sure that it is, you know, it's up to date and covers what the state of the law is today.
Yeah, thank you. And I asked that because a number of our members are either small nonprofits or small businesses that don't necessarily have an HR professional on their team that would be handling this and just being able to know where to go to get advice. Something I wanted to mention too is that as people prepare the workplace, and I'll be mentioning this again in the future sessions, but a number of our members have found sources for PPE, for masks, non-medical grade masks, and a number of our businesses have sourced screens. So if you have a receptionist or if you have somebody that's checking the temperature, for example, we also have access to disposable thermometers. So any employer that was looking for getting some of those supplies, that we have members who are offering them. And those might be things that you think about from the legal perspective of, what sorts of things are you doing to make sure that your workforce is protected?
Oh, absolutely. That's phenomenal, Barbara, that the members have those resources available for each other, because you want to try to do as best you can and as much as you can to ensure the safety of your workers and your visitors and all those things. So yes, making available face masks, just at least to cover. I mean, we're required right now under Executive Order 122 to wear face masks in public. I expect that kind of recognition is going to continue for quite some time. So making those things available at the workplace is critical. It's really critical.
Mm-hmm. Something that and I'm asking questions because no one has written a question in the question box. So I just want to remind the audience that if you do have a question, please type it in the question box, and we'd be happy to go over it. But I heard that Pennsylvania was considering blocking anyone over 65 from coming back into the workplace, and I wondered if you'd heard of anything similar to for New Jersey.
I hadn't seen that for New Jersey, but I had heard that about Pennsylvania, Barbara, and yeah, it sets up a real dilemma, because as an employer, you can't discriminate against somebody on the basis of their age, and then you have the government at the same time saying, well, but presume people over 65 shouldn't be in the workplace. I don't think there's an easy answer to that. I think my gut would be to say, look, we've got this executive order saying folks over 65 shouldn't be in the workplace yet. I think you got to abide that, but you're not going to know until there's a test case whether the anti-discrimination statute or the executive order rules the day. I don't know if somebody vetted that question, if somebody vetted that issue with the governor of Pennsylvania. The other thing, Barbara, you mentioned, in terms of, in addition to whether you have a handbook or not, a lot of employers do have employment practices liability insurance, EPLI. If you don't have that, you may want to check with your broker. Depending upon the size of just like with any other insurance, it's going to be size and experience rated, and sometimes they do have fairly substantial deductibles, $50,000, $100,000. But a single lawsuit for wrongful termination or discrimination can be really expensive, and sometimes the ounce of prevention beats that pound of cure. So check with your broker on that if you don't have it already. Barbara, I lost your audio.
That's because I had it on mute. Thank you very much for letting me know. We do have some questions in the question box now. And the first one is, would you be willing to share your presentation? May we share it with the audience afterwards?
Sure, I'm happy to do so. I don't take any pride in work product. It's right here. I'll pass it along to you, Barbara.
Okay, thank you. The next one was a question about whether we had access to medical grade masks, and the short answer is that a couple of weeks ago, we did have one of our members contact us saying that he had access to a supplier that had the KN95 masks. So if you want to follow up with me privately, I'd be happy to connect you to the person that said that they had them a few weeks ago. And then another question is that if you prohibit workers from eating in the communal kitchen and you tell them that they have to eat at their desks if they want to eat food, and also if you have a communal kitchen, do you tell employees that they're prohibited from using that communal space, or do you make regulations about certain cleaning procedures that each person has to do, knowing full well that a lot of times people don't observe cleanliness in communal kitchens anyway? So how do you handle that?
The tragedy of the common fridge. Yeah. The guidance that I've seen, obviously, is, and it'll be addressed by the environmental folks, is to really, limit the number of people in communal spaces. We're not going to be going to restaurants for a good bit, and even if when we start doing it, we're going to be sitting 6 feet apart for a while. Same thing in the workspace, I would imagine. I think it's a little bit of pain for the time being. I wouldn't necessarily say you can't put, you can still put stuff in the fridge, make sure it's labeled and appropriately sealed and that sort of thing. But employers would also want to, you do want to do some more due diligence on cleaning that area. You might have to assign somebody to that job because, like you said, Barbara, we don't always do it. But for the time being, limits on the number of people in small confined spaces, I think is going to be the word of the day.
Mm-hmm. And there was another part of that question too, which was if the person is eating at their desk and continuing to work, do you modify their hours because they're continuing to work while they eat, or do you say that even though you're sitting at your desk, it still counts as a lunch hour?
Right. I mean, if you're an exempt employee and you're subject to overtime and that sort of thing, you still have to abide by the 8-hour workday, the lunch breaks, the meal breaks, those sorts of things. Even if they are sitting at their desk, or if they want to modify their, if you can work with them to modify their day. Hey, I'm not taking my lunch break. I'm eating my way through work. That's within your purview, but you do have to abide the wage and hour and FLSA strictures.
Mm-hmm. Okay. All right. Chip, I don't know whether you have any questions you want to ask, if we want to come back.
Just one that I was in a conversation with a member the other day, and we were talking about employees coming back to work and the transportation that they took. And you mentioned before about public transportation and being cautious for the employee's sake, as well as who's traveling, as well as other employees, and talked about Uber or Lyft. Are there liabilities there too for an employer who were to arrange an Uber or Lyft ride and find that the driver or the car that they're driving is dangerous?
You're right, Chip. I mean, risks abound, and that was what I found a little annoying about the Center for Disease Control's suggestion that employers consider alternative transportation, but they didn't really give any idea of what that might be. It will be a challenge as we get back into the swing of things. I've read that NJ Transit is enforcing social distancing. Heck, I think we all saw over the weekend that Governor Cuomo and the MTA are taking the subway system offline for 4 hours every night to clean up everything. It presents a dilemma. It presents a dilemma for those folks who have to use public transportation to get to work. And fortunately, as Barbara noted, other members have PPE for employees. That's absolutely something to consider hey, I'm sorry, you got to, if you have to get to work on public transportation, let me give you the tools to help keep you as safe as possible. I think that would be, good advice to any employer.
Yep. Okay. Thanks. Appreciate it. Chris, thank you for spending time with us this afternoon to help. We thought the legal issues was a good place to start because, employers with liability for their employees' well-being, as well as for themselves, their corporations or their companies or their small business is very important. And I think you did a great job of bringing to fore a lot of the issues that we all need to keep in mind as we begin to get back to work. So thank you very much for sharing with us today, Chris.
Thanks for having me, Chip. I look forward to seeing you in a jacket and tie.
Yeah, well, actually, I'd rather not. So this works out okay. And to those of you who joined us today on the webinar, we thank you for being with us. As Barbara mentioned at the outset, we've got 3 more parts of the Return to Work series already scheduled. Wednesday morning at 10, the environmental aspects of preparing and sustaining a safe workplace. On Thursday, we're throwing in the midst of the Return to Work challenges. We're doing a little networking at our NRBP Nexus small group networking. Occurs at 1 o'clock, groups of 6 or so, 3 groups that are monitored or facilitated by NRBP staff will be on hand to do that. Go to our website to sign up. On Thursday, we'll be doing a second of our happy hours. Dan Palsy, who's one of the owners of Red's Beer Garden here in Newark, will be talking about some food pairings and different kinds of how beer and certain kinds of food go best together. That's something I'll definitely be, whether I'm happy or not, I'm definitely going to tune in for that one. And next Monday, again, Return to Work, we're back to social distancing in close quarters and how you might modify your space or your office to make it more accommodating, make it safer for your employees. And on Wednesday the 13th, the employee mindset, talking about the behavioral challenges, both for employers as well as employees in returning to the workplace. So with that, we certainly wish you to stay well and be safe. Please keep us informed about the challenges that you have. We can't necessarily get to the bottom of it or always resolve them, but it's good for us to know the kind of common themes that are running through our members' minds and how we might be able to address them through informative sessions like webinars. So with that, we wish you all well. We hope you tune in for another webinar very soon or join us for one of our networking events. And again, Chris, thank you. And my thanks too to the NRBP staff for reaching out to our members all the time and trying to be as helpful as possible. So thank you. Have a great day.